agree that corporate entities can use the park for recreational purposes. I completely agree with that. And that's why the use-user argument that the hotel makes and that the appellate court relies on is meritless. It's not that commercial actors can't do what everybody else can do. It's that nobody can use the park for the purpose of selling something.
Well, they aren't selling anything in the park. They're selling it next door at their hotel, right?
Yes, Your Honor. And they
and
claim...
I'm really not very persuaded by the argument that somehow the hotel has taken over this other piece of property in that main case that's relied upon. In other words, if anyone wants a drink, they got to cross the line and go to the hotel bar, right?
Your Honor,
or something outside like the porch where they're selling drinks that day, correct?
I don't think it's that clean. And if I may, I'd like to briefly run through what has happened as far as how these concerts are hosted. Because I think
I'm done with my question, so you can just pick up your argument. Thank you. Okay.
Okay. And Your Honor, actually there are additional questions. I did have 2 additional responses, but.
Thank you. If you'll hang on to that, Justice Doria.
Chief, I'd like to hear that before I ask my question. Why don't we let Mr. Grossen finish that?
Thank you, Justice Doria.
I appreciate it, Your Honor. Just quickly, on A335, Justice Keller, that's where you have the special exception. And it's 3.4 at the very bottom of A335, which says that certain uses are permitted by special exception only. So I don't read that as saying they are permitted without a special exception. And the other point I was going to make is a little bit longer, actually. So Justice Doria, I'll leave it at that.
Okay, I'll jump in there. How much does your argument depend on the 2008 variance where they? It doesn't. Okay, so the fact that they agreed not to have concerts, that's not your issue.
That's correct, Your Honor. That's a separate issue.
Okay, it's whether they can have, in your view, hold the concerts there. Okay, and then I guess then maybe you've answered the other question, but I'll state it: is there nothing here that needs to go to? You've come to the court for an injunction. Is there nothing that needs to go to a zoning enforcement agency or the zoning board or somebody to say, look, the town is in violation of? Do they have jurisdiction over the town to say you got to shut this down? For where I'm going, an exhaustion type argument.
Yes, exactly, Your Honor. And so, were we seeking relief under the variance, we would run into exactly that problem. And the trial court so held and dismissed our argument under the variance. We're relying solely under the zoning regulations themselves. Initially, we were relying under 12.3. The appellate court said, no, really, it's Section 19. We think that Section 19 is the wrong legal task. But even if you look to it, it also forbids commercial purposes in a park. So no, for that reason, we don't run into the jurisdictional issue, Your Honor.
Okay, thank you.
So just to return to my colloquy with Justice Keller, I think, Justice Kahn, I see your hand is raised.
Thank you, Justice Kahn.
Thank you, counsel. And I know that you want to get to Justice Keller's question, so I'll make this very quick. And I apologize. This is sort of a follow-up to that. I thought, why wouldn't you go to, because let's assume, hypothetically speaking, this case hadn't been appealed and your client won at the trial level. What would keep the town from doing the same thing? In essence, from going to another entity or even a nonprofit organization and saying, you know what, we're going to let you have the public like the concerts on Wednesday from 7 to 9. We're going to allow it to happen. So it seems to me that, yes, you chose to sue the hotel. I thought I read somewhere because you felt the town was aligned with the hotel, and so it was going to be a dead end to go to zoning. But since the town owns that piece of land, why isn't Justice Doria's question that, your case was dismissed as to the town, but why wouldn't you go to the town and say, because they're the ones who own the land and they're the ones who are giving these licenses. So why wouldn't you do that?
And Your Honor, that may well happen down the road. And I think because the 2008 variance expressly prohibits music that can be heard more than 50 feet away, and it's conceded by everybody that this music can be heard more than 50 feet away, they're illegal under the variance too. But that does require the exhaustion argument, and we're not there today. I do think, however, Your Honor, that doesn't change the analysis under the expansion of non-conforming use doctrine. And because this is a non-conforming park, we have to look at the actual historical use. And I understand that the appellate court's argument is we look to the reg instead, right? We look to the word park. And because there's no distinction under that, no other distinction matters. In Cummings versus Tripp, footnote 16, this court expressly rejects that argument. In that case, you had cottages, and it would have been easy to say cottages are cottages are cottages. But instead, this court held that the fact finder properly said changing from seasonal to year-round is a change in the character of the use under the Zaks test, even though the regs did not distinguish. So the exact argument that the hotel is making here today, and that the appellate court accepted, this court rejected in footnote 16 of Cummings. And I think that's critical. Another case, De Felice, in that case, you have a commercial sand pit. It goes from being a commercial sand pit with one kind of equipment to a commercial sand pit with a second kind of equipment. There's no reg that says that equipment is a different label under the zoning regulations. This court still held that the fact finder properly considered that a change in the character, purpose, and the effects on the neighborhood. And so it was properly held to be an illegal expansion of a non-conforming use. The regs were not dispositive.
Thank you, counsel. I see other hands are up, and I don't want to take you away from following up on Justice Keller's question. Thank you.
Justice McDonald.
Counsel, one of the things I'm having a difficulty understanding here is that the injunction is against the hotel, right? It's not enjoining the use. I mean, the problem is it would really have to be an injunction against the town from permitting people to use the town's land for any concerts, not the hotel for this specific concert. Why isn't that a problem for you?
It's not a problem, Your Honor, because that would be an act. Think of it this way. There's two types of relief that we could get. We could tell the hotel to knock it off, or we could tell the town to knock it off. Because of the types of activity that have been held so far, one is sufficient. The second would probably be more expansive. I agree, Your Honor. And we might be able to go down that path as well. But I'm not aware of any case that says that we can't take the first one only.
Okay, well, I mean, you know, I don't know who owns the hotel, but let's say it's Mr. and Mrs. Jones own the hotel. Why couldn't Mr. Jones then just apply for the exact same permit or license to have that he would be funding or she would be funding the concert series? The injunction isn't against the use, it's against a entity for something that's happening off of their property.
Well, I want to be clear, Your Honor. Injunctions always have a particular defendant in mind, right? That's how injunctions work. This case is no different than any other in that respect. We are enjoining, or the trial court rather, is enjoining the only person who's trying to do the illegal thing. If more people try, then we'll have to sue more people.
It's not the only person, it's the town. The town is permitting it to happen.
But, Your Honor, I think you have to read the trial court's memorandum of decision, and the trial, I don't mean to patronize, Your Honor, I apologize for the phrasing there, but the trial court makes extensive findings about who's really behind the curtain, right? And it's the hotel that's been backing this since 2012. Before this particular hotel corporation buys into the neighborhood, nobody's trying to do this. The town's not trying to do this. So there's no need for an injunction. It's this particular user who has engaged in the illegal activity.
Okay, thank you.
Justice Keller.
Thank you, Chief. So, Attorney Grosjean, what if the town granted a special exception to this area? I mean, it's its own land, so the town could apply to the zoning board for a special exception, correct?
Absolutely.
And then this would be legitimate, correct?
I think so, Your Honor, if it's granted.
All right.
And I want to be clear here.
And I think, can I just say, I think that, doesn't the fact that the trial court relied on the Crabtree decision, buttress and joining the hotel, because the trial court basically decided that, like the used car dealer in Crabtree, that they had kind of, I don't know, glommed this park and made it part of their land. I don't really buy that analysis, but doesn't that, I mean, I'm liking Justice McDonald's question, because if you don't have Crabtree, how can you just enjoin the hotel when they really have no possessory interest in the park?
Your Honor, I think that there's a couple questions baked in there. To the Justice McDonald question about did the trial court enjoin the right person, basically? I would note in Crabtree true, and in almost every single zoning case, you could in theory sue the town and say the town is the one who has permitted this particular neighbor to engage in this particular noxious use.
But it's different here, because not only are they permitting it, it's their land that they're permitting it on. It's owned by the town.
It is, Your Honor. And I do want to nuance that a little bit, in that although it is the town's land in name, the hotel has been operating as though this is the hotel's land since 2012. I think it's significant that when the hotel first starts these concerts, they sign a contract with the town giving them exclusive use of the grassy strip for a year. Those are the auspices under which these concerts start. They have in there a land swap provision where the hotel acquires title to the grassy strip and becomes the owner. That falls through. So in 2014, the hotel tries to do the same thing via a zoning change and gets the town to try to rezone the land as commercial, both the hotel and the grassy strip, with the same land swap. The trial court strikes that down as illegal spot zoning, saying that this is for the sort of an ad hoc handout to the hotel, not in accordance with the overall zoning plan. And so that falls through as well. So where the hotel is left with is basically trying to exercise dominion over the same property it's been trying to exercise dominion over since 2012, only now it decides to just do it. It's tried two ways to go through legal process, so now it's just using the land for these commercial concerts. And the trial court here, I think, properly said, this is more of the same. We know where this is coming from. This is not truly a separate property. They're being used jointly.
All right, thank you.
Justice Mullins.
Thank you, Chief. I have, I think, relatively more basic question. I'm trying to see if you can untangle for me. The appellate court concluded that it was the classification of the land as a park that was grandfathered in versus grandfathering in the specific actual use.
Correct.
Could you? That seems to make sense to me, but could you tell me why you disagree with that if you do?
Absolutely, Your Honor. Simple example, one of the other labels in the definitions under the zoning regs is research and development facility. You could, in theory, have the same argument. An R&D facility is an R&D facility is an R&D facility. And so you have one R&D facility that starts out making enriched breakfast cereals. Now it wants to research and develop cold fusion. Under the appellate court's analysis, legally, a fact finder cannot find that that's a change. I think that result is absurd. And I also think that it is rejected by this court's holding in footnote 16 of Cummings, which says that that label in the zoning regs is not dispositive. It can be sufficient to find that there's an expansion, but it's not necessary to find that there's an expansion. And
okay, I have to think about that a little bit, but okay. I think your time is up, or the chief has a question.
And I do, and this is probably more in the category of my idle curiosity, but is this a designated park?
I don't know precisely how Your Honor means that. The parties did stipulate that this has been used as a park, but it's not zoned as a park.
No, I mean, is it a designated park? There's certain state requirements concerning parks, and you can't diminish them or increase. I guess you could increase them, but you can't diminish them in any way. So I was wondering about that.
I truthfully, I don't know the answer to that, Your Honor.
That's okay. Thank you. Please, I believe you're out of time for your main argument. Is that correct? And Justice McDonald, I think you informed me that the argument went a little long.
Yes, that was actually 30 minutes. So you have your 5 minutes and the appellee will have 35 minutes.
Thank you.
Thank you, Your Honor.
Counsel, whenever you're ready. You're muted, counsel. You're muted.
Good morning, Your Honors. My name is Damian Gunning-Smith, and I represent the Madison Beach Hotel and the Madison Beach Hotel of Florida. I'm joined today by Dave Hardy in my office. He'll remain off camera for the duration of the argument. Your Honors, fundamentally, this case is about whether a series of free public concerts in a public park are permitted under the Madison zoning regulations. That's been the Madison Beach Hotel's position from the start of the case through the appellate court and now. The appellate court's decision was simple and straightforward that, in fact, you can have concerts in a park, that this was a park, and that therefore it was permissible as a matter of law, and the trial court's injunction was vacated and remanded. Your Honor, the appellate court's decision was right for really 3 reasons. It was legally right because it was consistent with the use-user distinction that's fundamental to zoning law. It was logically right because it created clear and definite rules for people who use land to know what they can and cannot do on that land, and it created clear rules for enforcers of land use restrictions. And it was wise. It was a wise decision because it avoided arbitrary outcomes where one person in the town of Madison can't use a park in the same way that others can. And for those reasons, that decision should be affirmed. I see I have a question.
Thank you, counsel. Justice Keller.
Thank you, Chief. So if they wanted to put, if someone wanted to build or if the town wanted to put a skateboard park in that land, that area of land, your argument would be that it would be permitted because that's an active recreational, that's what parks are for, active or passive recreation, correct?
Absolutely, yes.
And even though we could probably assume that prior to 1953, there wasn't a park in the town that used that had a skateboarding park, that won't matter, which I think your opponent is saying, yeah, it would, yes, it would matter because it's non-conforming. It can't have a use in it, active or passive recreational use that didn't occur in that park before 1953. Do I have your arguments clear?
Yes.
Okay. Tell me if the amendments in 1970 make any difference here.
They don't, Your Honor. The amendments in 1970
in the 70s, I mean, in the 70s.
Correct. 1977, yes.
Yeah. Why shouldn't you have to apply for a special permit if you want to have concerts when no one can tell you whether there were ever concerts in that park before 1953?
Your Honor, because it was a public park. It is deed restricted public park. Gifted to the town of Madison. It was permitted in the zone after the 50s when zoning was adopted. And then in the 70s, when they decided that parks needed special exceptions, they were layering that requirement on the existing zoning framework. The existing zoning framework was parks are permitted, and they're still permitted in that zone. So the only thing added to the zoning regime in Madison at that time with respect to parks was a special exception requirement. So the town didn't require any of its parks to do that. And from a practical perspective, that it would be really difficult for any town to go back 100 years and start inventorying the potential uses of property. And so if you look at the law as it applies to expansions and extensions, what's happening here is the plaintiffs are trying to turn the burden on its head. To the extent that you have to establish that there's a non-conforming use, They have to establish that there's an expansion or extension. And there's a stipulation across the board that this has been a park. It's a public park. That's stipulated in the record. So if they want to make the argument that there's been an extension or expansion, it was their burden to do so. They can't flip it on its head and say you have to prove the exact thing you're doing occurred prior to 1977. That would have been their burden to the extent that's the correct analysis. But I guess what I would say is one of the reasons, and I noted Justice McDonald said it's confusing here somewhat, why the town's not a party to this. And it is confusing, and the reason it's confusing is because of the arguments that the plaintiffs are now advancing. This wasn't the case. It wasn't the case below. Their count 13 of their complaint, which was their alleged violations of the zoning regulations, was directed only to the hotel. And the reason it was directed only to the relief sought was directed only against the hotel, not the town. And the reason they sought that relief only against the hotel is because their theory of the case was that we were expanding the non-conforming uses of our property, the hotel property, onto the park, which is what you've heard quite a bit about. And that there was sort of two things there. They argued we violated section 12.3 because we expanded our hotel. We didn't have the right to do concerts in the hotel, so that was an expansion. And then they said we were also taking our commercial operations, which depended upon that combined effects analysis from Crabtree. So really, it's a combined effects analysis. They're sort of getting at the same thing two different ways. And it's telling that that they didn't in fact seek that relief against the town because that's the consistent way that the case has been argued, and that's the way it was decided by the trial court. And you can see that in particular with the trial court's May order in 2018 prior to his memorandum decision, which was really just an articulation. He only found a violation of 12.3 because we were extending, allegedly, our commercial operations into the park. So, really, it's a new theory of the case that's coming before the court in the Supreme Court for the first time. So we heard a lot about the Zacks factors, and it's interesting to hear a lot about. Oh, I apologize, Your Honor. I see that I have a question.
Counsel, please finish that thought, and then I'll go on with the other justices.
Oh, I was just going to note that to the extent we talk about the Zacks factors, there's no application of the Zacks factors in the case, and the reason why is because they never asked the court to do that, and they pointed in a footnote in their reply brief that the Zacks factors are preserved, and they pointed to the trial court's memorandum decision. But what you see is the trial court says we're not applying the Zacks factors because the hotel can't expand its hotel operation onto the grassy strip. That's the context. It's not the argument that's being advanced now for the first time in the Connecticut Supreme Court.
Thank you, counsel. Justice Khan.
Thank you, Chief. Counsel, I have two questions. One is, and of course the town is not here, so it probably would be a better question directed to the town, but are you aware or was there evidence of other people retaining licenses to use that grassy strip for other purposes?
Honestly, I don't recall the record precisely on that issue. There may have been evidence that other people had applied for permits for things other than concerts, but I don't know off the top of my head the answer to that question.
Okay. And the town could certainly restrict licenses. The town could determine that under what conditions it would grant licenses to use that space and put other limitations on it, correct?
Absolutely, Your Honor. The town can always impose reasonable time, place, and manner restrictions on all sorts of activities in the town.
So if the town wanted to say, we'll give licenses to people to have concerts, but these are the restrictions, they must, they can only play from 6 to 8, not 7 to 9:30. And you can't have more than, 500 people on the strip or, conditions like that. The town could impose those.
Absolutely, Your Honor, yes.
Thank you, counsel. I see my colleagues have questions. Thank you.
Justice Doria. Thank you, Justice Khan.
Thanks. Do you know in 2008 about when the variance took place, do you know if the neighbors were, I'm not going to use the right parlance, I'm sure, but if they were interveners, or if they were, they weren't parties to the ultimate agreement, I suppose, but do you know anything about that?
My understanding of that would be that there's, I believe, statutory notice that has to be given with respect to any variance application. There's never any dispute about whether there was proper notice or anything. I assume that occurred.
So you don't know whether they opposed the variance or anything at the time?
No, they did not oppose the variance at the time. I think that is clear from the record.
Oh, okay. So the town got certain concessions. I mean, you can see, I guess, or can you see that there would be, I don't know if there is such a thing as, like zoning estoppel or something, but, you agreed not to have concerts inside or outside on your property, but you're just going to have them out on the grassy strip. Even if the town goes along with that, there's a way of looking at that as I see this case as how you look at it is, are you expanding your non-conforming use, or are you using something that anybody else could use? Why is the so necessarily the latter when you agreed not to have these concerts?
Your Honor, I guess this goes fundamentally to the use-user distinction. A single person can own property and do something somewhere else, and they're not necessarily related. The question is not, so it just doesn't matter ultimately whether or not, we agreed to limitations with respect to our property, because we have in fact agreed to those and we continue to abide by them. It just fundamentally is, what can you do in the park? And it shouldn't matter who is doing it. And that's the fundamental principle that applies to land use restriction.
Okay.
Justice Keller.
Thank you, Chief. I wanted to ask you about your alternate ground for affirmance. Did you ever raise in front of the trial court a freedom of expression issue in order to defend against an injunction?
No, we did not, Your Honor.
All right. Was this raised before the appellate court?
Yes, it was, Your Honor.
They didn't reach it.
Yes, they did not reach it.
And why is this reviewable?
It's Golding reviewable. It's a constitutional claim under the First Amendment, and it's appropriately reviewable on appeal. And
do we have an adequate record to review a claim like that when we don't know, we don't have a lot of the factual nuances we might need?
I believe the court does have an adequate record, because the record is that the court enjoined.
I mean, what's the expression that the hotel has? They're not the band. They're not the player of music. I'm having a hard time with this one.
Right. So whether or not we are the ones engaging in it, we can pay someone to engage in expressive activity on our behalf.
Okay.
And that's what's happening here. We got singled out. Ultimately, from a First Amendment perspective, it doesn't make any sense that a single person in a town can engage or pay someone to engage.
Well, we don't even have, I don't know how much evidence we have of that. Do we have evidence that you were unable to go anywhere else? That there wasn't a park in some other part of town?
Your Honor, the issue is not, so that sort of analysis that you're driving at would be a time, place, manner restriction.
Yeah.
And the problem is the time, place, manner restriction, and the appellants have cited Hoosty a bunch, is that it's a neutral rule that applies to everyone equally. And what you have here is not a neutral rule. You have a rule that's targeting one person for some reason. It's targeting us because they, for whatever reason, feel that we're not abiding by the rules of the town. But I think the point is, if you can do it in the park, if someone else can do it, there's no reason why you could restrict us from doing the same thing. So, in that regard, I don't think that the time, place, manner restriction analysis, would apply correctly, because you're targeting us individually.
Thank you.
So I guess I'll also talk, yes, Justice Story, I see as a question.
You're still muted, Justice Story. No, you're not.
It's okay. There it is. Thank you. I think there was an outside force that let me do that. Yeah, but that's kind of the point. Is that we don't know why you're being targeted. I don't know how we evaluate that. I mean, you might be being targeted because you're right next door, and I'm not. That's certainly not content based. Or you tell me if you think differently. So, I mean, you're probably the most likely to have the concerts. I suppose the town might say. I guess it might be said. The court might say we're going to enjoin the people that had agreed not to have these concerts. So I certainly don't know what level of scrutiny we'd give that, because I don't know if it's content based.
Your Honor, it's not identity based determination about who can engage in expressive speech. So there's no way to infer that there's some sort of content neutral basis for the application of the rule. It's targeting one person and one person alone, and that's us. It's not targeting us because of the concerts. Just as general.
The it is the injunction.
The injunction. Well, I mean, we've attacked the injunction on two bases. One being that it shouldn't have. Just as a matter of the First Amendment, it violates the First Amendment because it targets us in a way that it doesn't target everyone in the town of Madison equally, and therefore, you have to infer from that it's a content-based restriction. It's something about what the hotel is doing.
I mean, that's a little bit of, almost a tautology. I mean, the judge found that you violated law. I mean, he may be wrong about that, but that's why you're being singled out. There's nobody else in his view, that's anybody else before the court, but there's nobody else that, in his view, violated this. So I don't think, the idea that he was doing it for speech purposes seems a stretch.
There's no one else that could violate the law. That's the problem. There's no one else. If we're the only one that can violate the law, then it has to be a problem with us and not with, it can't be just some general rule that's being applied. I see I have another question.
Hang on one second, counsel. Justice Keller, you had your hand up first. Do you still have your question? No? Thank you.
I took it down. Thank you.
Thank you very much. Justice McDonald.
Counsel, I'm trying to work through my computer because I don't have the appendix. I was looking at it electronically, but the 11th count of the complaint sought an injunction against the town. How was that handled? I can't find it in the memorandum of decision how the 11th count was addressed or resolved. Do you know?
One moment, right? The 11th count. So as I recall, ultimately, the 10th count was partially dismissed, and the 13th count is on which the court entered judgment. And I don't recall what the determination was with respect to the 11th count at this time.
Let me ask you this: is there a final judgment problem in this case, or were all of the counts of the complaint addressed and resolved by the trial court?
I have not identified any final judgment problem myself. I'd have to go back and look at that. I've been focused on appeal on the 13th count, which is
and I understand that, but I mean, I looked because I knew the town was a defendant here, and they haven't filed any briefs, but the injunction sought against the town was sought in the 11th count. And that's where you would think that the injunction would be for a case of this type when the town is the owner of the land.
So I'd have to look. There was a withdrawal filed, a partial withdrawal, and it might be addressed in that. I would assume.
I'll pace it down. I won't take up any more of your time. Thank you.
Okay. So, so fundamentally, we've taken the position and been consistent throughout the case that the court should respect the use-user distinction, and that should not adopt any sort of combined effects analysis as advocated for by the plaintiffs below consistently. That's the one consistent argument that they've made, and that the court should reject any sort of Crabtree type combined effects analysis. To the extent that the court isn't the appellate court distinguished Crabtree on the basis of the license versus lease and the degree of control over the adjoining property. And that is a logical and reasonable basis to distinguish Crabtree. And in fact, Judge Bishop was on both panels. So I think that's a completely reasonable approach to that, dealing with that issue. But if the court's not persuaded, Crabtree is just, it doesn't appear to me to be a good rule for the state of Connecticut, or for any state for that matter, and should be overruled to the extent that this court passes upon that issue. The only other issue that was addressed briefly in the opening argument was the distinction between commercial versus recreational activity. My opposing counsel identified commercial and recreational as antonyms. I don't know where I don't know where that comes from. I think that realistically, the only issue is whether you can have a concert in a park, and the question is what can you do in a park? And you can do recreational activities, and there's no categorical distinction between commerce and recreation as it applies to that. So there's just no basis either in the regulations or under the law in any manner to reverse the appellate court's straightforward, simple judgment that in fact you can have concerts in the park. And in this case, that judgment should be affirmed. I don't have any other questions. I don't have anything else further unless the court has additional questions for me.
Seeing none, thank you very much, counsel. Mr. Grossa?
Thank you, Your Honor. Justice McDonald, A252 footnote 10, all of the counts except for 10 and 13 were withdrawn. So that's the answer to the final judgment question. I want to start with Justice Doria's observation that this case really depends on how you look at it. And I think that's right. And I think that's why this court in Cummings and Helicopter Associates and so many others has held that whether you have an illegal expansion of a non-conforming use is essentially a question of fact. What the trial court here did is it looked to the actual of this strip of grass, and it did not say that the Zacks factors were irrelevant. It said, and this is at A272, that it is obvious to everyone that the hotel would be in flagrant breach of numerous zoning regulations, the variance, non-conforming use regulations, or both, if this concert series were held on hotel property. So what the trial court said is not that we're ignoring the Zacks test. It said under the Zacks test, the hotel's case is an obvious loser. The only defense that the hotel has is that you have to erect this artificial barrier between the two lots.
Justice Cohen.
Thank you, Chief. Counsel, and let's take a look, so if how we should review this case is based on how we look at the case, I guess, I understand that the neighbors are concerned about the noise. And certainly for some neighbors, particularly those abutting the hotel, that it's incredibly loud. But we're talking about 10 or 12 concerts in the summer, originally on a Thursday, now on a Wednesday, from 7 to 9:30. Is that something that we should consider?
I think it's something the fact finder should have considered, Your Honor. And the fact finder made a finding that these concerts were obnoxiously loud for a residential neighborhood. And it found that there were adverse effects on the neighborhood. The town had to call in extra police. There was traffic spillover into the surrounding lots. For this tightly packed residential neighborhood, that was absolutely a factor. That was an ingredient in the soup. And the fact finder was the one who got to decide at the end of the day, do you have an illegal expansion of non-conforming use? Where the appellate court erred is in looking at precisely that kind of factor and saying, we know better. And I think that was error.
Well, isn't the question before us really a legal question, not a factual one? And I noticed the Chief and others have their hands up. So if you could just answer that question. I mean, part of the claim here by your opponent is that the court got the standard wrong and that this is a legal question and, in fact, not a factual question. If you can answer that, and I won't have a follow-up. Thank you.
So different pieces of the analysis have different standards of review. If we're asking, look at the language of Section 19's definition of park and tell me how to interpret it, that's clearly a question of law. No argument there, Your Honor. If we're looking at the effects on the neighborhood and we're asking, is 7 to 30 fine? That's not a legal question. That's a factual question. And we defer to the trier on that type of analysis. Just because there's a legal question at the top doesn't mean that we retry everything underneath it.
Justice Keller.
Thank you, Chief. Attorney Garoshin, why is it your burden to prove that no one ever had a concert on that park land before 1953?
One, I think it would be perverse to have us prove a negative, Your Honor. If we're
It's probably perverse to try to get anybody to have to try to prove that, correct?
I don't think so.
I mean, I don't think it's more unfair to you than it is to the other side to try to prove that.
What?
You're seeking an injunction. That's an extraordinary remedy, I think. And you're claiming that the use of the park is non-conforming and it's an illegal expansion of a non-conforming use. And why shouldn't you have to show that?
So I do want to be clear. The hotel's burden, if we acknowledge that that's where the burden belongs, would be affirmative. They would have to say, here's the record, here's where a concert happened. I would know the hotel has done this for other parks. It's not impossible. They pointed to concerts that have happened in the historical record elsewhere. They just haven't been able to point to one that happened here. And that's why they're stuck making the argument that we have to prove a negative. The other thing I'll say is that regardless of where you look at the burden, the trial court here found as a factual matter that these new use as a commercial concert venue was beyond anything that had happened before. So I do think that that's important, Your Honor. And the test that we examine it under, those Zach's factors, what's the purpose, what's the character, what are the effects on the neighborhood, those are quintessentially factual in nature. So those are the types of matters where we should defer to the fact finder. And to address Crabtree too, Your Honor, I understand there's a lot of skepticism of Crabtree here today. I think what Justice Peters was getting at in that decision is, as a general matter, it makes sense for this to be a fact question. There's really two times where it doesn't. One is when you have NIMBYism, and the second is when you have regulatory caption. Those are two times where the fact finder, especially if it's the local zoning board or P&Z, might not do what the law requires, and so you need more teeth in your review in order to get around that. In our case, in the 2015 Menino decision and in the trial court's decision here, both of those independent judicial officers said basically, this is a regulatory capture case. The town is along for the ride and is enabling the hotel. So I think for the appellate court and for this court to reverse that is a mistake. If we look at the actual conduct here, what you have is a hotel that bought in, demolished the existing hotel, got a new variance, built a new hotel, and started throwing commercial concerts. There was nothing in the 100+ history of this grassy strip that screamed commercial concert or the legal test. Was it known in the neighborhood as a commercial concert venue? There is nothing in the record that establishes that this park was known in the neighborhood as a commercial concert venue. And again, that's the language from Helicopter Associates, the language that this court would have to find in order to establish, or that the trier of fact would have to find to establish a non-conforming use. So I see there's a question.
No, please finish your answer. I believe your time is up, but I'm still having a problem when you talked about the effects of the use on the area, which go back to Justice McDonald's point. That doesn't seem. I'm having a problem with that theory. If the hotel, instead of having concerts, this type of concert, had a group of mimes, wouldn't it still be a violation? I think
truthfully, Your Honor, I don't know the answer on that one. I think that's an edge case. But I think what you would look to there are the same three Zach's factors, and the effects on the neighborhood in that case would be much less. So the trial court would have to find that there was a change in either nature or purpose. And that one of those two factors would be the basis on which you say this is going beyond what has happened before. But I will candidly acknowledge, Your Honor, there are edge cases. I don't think this is one of them.
All right. Because this is really unusual. I don't think I've ever seen a case quite like this before. And I've dealt with expansions of non-conforming uses quite a bit in my prior life. I've just never seen anything like this. All right. Well, thank you very much. With that, we will adjourn for the day. There is no court tomorrow, so it'll be Wednesday. Thank you, counsel. Once again, sorry about the technical difficulties. I really appreciate your patience. It was an excellent argument, and very well appreciated. I'll see the justices at, why don't we say 12:30, and we'll talk about this case first. Thank you.